Good morning and welcome to regular session, Monday, May 20th, 9 a.m. We have a quorum present with Commissioner Doggett absent.
Nope. Oh.
Decker, sorry. Yeah, Carrie, do you certify the meeting was probably posted? Please rise for prayer and pledges.
Our Father, we humbly bow before you this morning, and we ask for your presence in this courtroom, that you may guide each individual commissioner and the judge in the direction that they should go for the residents of Walker County. Father, we thank you for your presence. We thank you for 1 John 4:9 that says, "In this was manifested the love of God towards us, because that God sent his only begotten Son into the world, that we might live through him." Father, may we focus on the live through him part. Father, may we not always live to ourselves, but that we live through Jesus, that we allow him to lead us and guide us in all that we do, and that all that we do may be pleasing unto you. In Jesus' name I pray, amen.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. On the Texas flag, I pledge allegiance to thee, Texas, one state, God, one indivisible.
We have one citizen's input, Ms. Rigsby.
Good morning, Ms. Rigby.
Morning.
Respectfully, for the record. Once again, and I do so. Item 5. Simply asking that you take careful attention. Invoices and things that are submitted. I say that again. I have been in very sensitive situations, not by choice. And I say not by choice. Each time I've had to make a stand, it turned up to be something. And I know that in this case, and when I say case, we've had COVID funds that were dispensed to us at the county. I stand representing hundreds of citizens, vulnerable citizens. I've said this time and again, over 85% of the child welfare cases come out of precinct 3. I live in a different precinct, but I represent those people. Hundreds of people. Senior citizens that were completely overlooked. I realized that funds were strategically dispersed, whether it was the sheriff's department, the hospital, Tri-County. These places were not impacted nor severely impacted. And I stress it when it comes down to children. I am a representative of the most vulnerable. And there has been conviction. I say we have counsel present. There in Montgomery County when the district attorney had to say something. And it came to pass. Very popular people. Sam Houston State University professors. Is for the record, cases that can be looked up with Social Security. So I just say as a voice, I am a voice for these people. And it looks foolish, but God has assured me that he's going to use the foolish things to confound the wise. Thank you for your time.
Thank you, ma'am.
Thank you. We got consent agenda, 15 items
I don't need to pull anything, Judge.
Good.
on the file.
I'll make a motion, we accept the consent agenda for number 5.
Second.
Moving second, all in favor, raise your right hand. Motion carries. Number 5, approved claims and invoices submitted for payments.
Ms. Patricia, on page 4, under Sam Houston Funeral Home, there is a transport fee and a refrigeration fee. I'm assuming we held that person for a while, maybe something you need to look up and. catch back.
Talking about the first one.
Yes, ma'am.
Any comment?
Sure.
Yeah, so,
Yeah. Yeah.
JP One Fisher,
Mhm.
they had a body that was deceased. He was questionable on if they wanted to do autopsy or not, and he did some research, held the body, and then some of the stores didn't add up, so he sent it on. That's where the refrigerator.
Refrigeration is.
Yeah.
All right. Sounds good. On page 15, Mr. Fisher, there's a one about a fire truck of Texas for like $16,000. What is that?
15 then?
The bottom.
Bottom.
Very bottom.
Oh, okay.
I'll have to look it up
Okay.
specifically. It would have been damaged.
Mr. Earl?
Fit, Fire Trucks of America, isn't that an upfit to the, one of the sheriff's office? If it's not the sheriff's office. Constable, thank you.
Bartix.
Precinct 4, right?
No, she's refreshed my memory. I think that it is definitely an upfit on a sheriff department vehicle that's coming out of 105. So it is either the as the constable or the sheriff. We can get you the exact.
Okay. Thank you. That's all the questions. I
The
have.
fire trucks, I'm thinking fire.
Yeah, well, I was too.
Yeah,
So,
no, it's a new outfitter that we were using instead of,
Top cop or whatever.
yes,
it was.
that one,
Yeah.
Paul Wilkin.
Yeah, it's very similar to mine, this one.
Yeah.
And
Okay.
and somewhere in the back of my mind, I'm thinking it's the livestock truck, but I could be wrong on that. I'll get you an exact date.
Okay, so that would be the sheriff's department then, huh?
Yes, I think so.
Okay. Anybody else?
No, I don't have anything.
I'll make a motion, we accept number 5.
Second that.
Moving second, all in favor, raise your hand. Motion carries. Number 16, discuss and take action on approval of solicitation C2360-24-006 at fault and pay.
Good morning.
Cheryl.
So we did a solicitation for asphalt and paving, as requested by precinct 1. We threw in, one road for precinct 2. And the bids came back. We had 3 bidders. That was Larry Young Paving, Smith Paving and Construction, and Vulcan Materials, Asphalt and Construction. Vulcan Materials and Asphalt and Construction came in with the lowest bid. A total of $878,689.62. They bid $14.32 per, help me.
Cubic yard, square yard, I meant.
Yes. And.
14 what, Mr. What was your?
$14.32.
You know what the others was right off?
Yes, so Larry Young bid $16.80. And Smith Paving and Construction bid $17.10. So again, with that being said, we offered a best and final offer. Larry Young came back and he had dropped his down to $16.25 square yard. I don't know, piece of paper.
Vulcan Materials is the people that sell this material, right?
Yes.
Well, they ought to know what they're doing.
Yep, construction.
Cause they buy the material a little cheaper than the other guy.
Yes, they have produced it.
Yeah, they produce it, so.
And he-
So we're here to discuss whether you guys wanna award this in its entirety to Vulcan Materials.
I would,
Asphalt.
I'd say let's move forward with it.
I'm good.
Their bids, checked out, all their references, they do, demonstrate the ability to do paving.
I would imagine they should be able to. Is that your motion?
So you ready?
I'm ready.
I'll make a motion, we approve solicitation number C 2360 24 006.
Second.
Sorry? Vulcan Materials.
Asphalt and construction. Oh, I got it.
It's,
That's in your motion. And that's in my second.
Second, all right, moving second, all in favor, raise your hand. Motion carries. Number 17, discuss and take action on approval of solicitation C 2360-24-005. Upgrade Cisco LP infrastructure and system services.
This one,
Air conditioner over here.
is that six?
This is air
this
conditioner,
is
sir.
Cisco one.
Oh, I'm so sorry. So this is I don't have that information with me, but it is to upgrade the telephone system. We had bid that out as well. Dan, if he's on the line, he may want to speak to you guys in reference to this. I know that we had held negotiations with this vendor. And he has come back and approved everything that was submitted by the vendor. When we even had additional, but this needs to take place from what I understand. Because all of our telephone systems are obsolete.
So how much money we looking at? Dan, you out there?
Yes, he is.
Yes, I'm out. I'm here.
Tell us what's going on, Dan.
The current phone system is end of life, software and hardware support wise. So if we have any major issues with it, there's no support.
Is this something we budgeted last budget?
This would be coming from project funds.
This was budgeted several years ago as part of the capital projects fund. Where the same time we budgeted the 5 million, there was 500,000 budgeted for projects such as this.
Okay.
Do the whole phone system.
Correct. This is software and all the hardware that's related, server, phones on the desk, voice gateways. It's a complete replacement system.
And this is still the same company we had before, right?
No,
Different.
this is an E-Consortium. E-Consortium is the vendor that we're wanting to award to.
Okay.
Okay, well, give us a number not to exceed, because I don't like to give you an open checkbook.
Oh, go ahead.
This is the best and final offer that come in, Dan? It was
Yes.
343,644.72.
Does that include the phones?
That includes
Yes, it
everything.
does.
What was the company name?
E-Consortium.
E-Consortium. Down there.
And they're doing
Anybody got
the,
any question?
are they doing the install and everything?
Turnkey.
Are we hands
Yeah.
off on this? They're gonna show up, do it all, configure everything? Or is Dan doing that?
No, it's hands off. They're going to configure and install. Part of the price also includes them going to all locations, do a full functionality test.
And I'm to assume, since you're standing here, all the purchasing procedures have been followed?
Yes, sir.
I
I would not be here.
didn't figure that you would, but I just had to ask.
Tell the court about this particular company.
E-Consortium, they are a DI, not much, to be very honest, no. We have visited with them in length as far as their, references, and what they have done in the past and who they have, done for, services. And did not want to, I don't want to be ugly about it, but they did not want to continue paying DIR for something that they really didn't need. And so they bowed out.
Are they requiring money up front? None? Okay. That says a lot about a company too, so.
Just that we all know Cisco. Never heard of E-Consortium.
E-Consortium is, they have Cisco equipment. It's not that they're not, familiar with Cisco, that because Presidio is the exact same. Presidio was our previous vendor, they sold Cisco as well. But these guys have tech certifications in Cisco and installing the equipment such.
So you're saying that this is all gonna be Cisco equipment?
Yes,
Okay. That's good.
So we're staying with the same type of equipment, what Clinton.
Just the newer stuff, just the
Yes.
newer models.
Yeah,
It's just
it's a-
updated.
Correct, that is correct.
Are you okay with this, Dan? I mean, you checked into it pretty thoroughly.
Yes, sir.
Okay.
They came and talked, they did Prairie View A&M and a couple other colleges and municipalities. They talked way over my head.
It don't take much on me. That's why I asked
So-
Dan. He's okay with it, then
I'll make a motion to approve number 17
you'll put the dollar amount
for $343,644.72
not to exceed
Not
at
to
this point,
exceed
unless you come back to
from-
court.
From project.
project
funds.
project contingency funds.
I'll second
There you
that.
go. Moving seconded, all in favor, raise your right hand. Motion carries. Number 18, discuss and take action on purchase of tires.
we're gonna remove that.
Okay, just gonna pass it,
Yes.
pass on
Yes,
18.
remove the tire.
Alright,
But hang on to, we have that again.
yep,
Yeah,
it's coming back later.
yes, it were.
Okay, I think we're passing on 19. Number 20, discuss and take action on the current process of collecting fees from patients requesting medical records. Rachel? Oh.
Yes, hello. So we're just kind of going through some of our processes, and one of the kind of old processes that we have was for the state says that we can charge $25 for up to $25 for medical records. We don't have a ton of patients coming in requesting their medical records. I think we had 3 patients come in the past year and directly ask for copies of their medical records, or they're a guardian of somebody and they needed their medical records. So we were just kind of thinking probably best practice would be to just waive that for a patient or a guardian of a patient. We still will collect $25 from attorneys' offices, retrieval companies, things like that. That's kind of the standard. And then this also doesn't really apply to like law enforcement, DPS, anytime records are requested that way. But we just kind of wanted to waive it for patients coming in. So we just kind of wanted to update our internal policy on that.
Sound like it's more trouble than it's worth. All right, so the motion would be to eliminate the collection of fees from patient requesting medical records. Rachel, is that what you wanted to say?
Yes, yes.
Adopt new fee structure.
Yeah, follow the new structure, right?
I'm sorry.
Well, the structure's still the same. I mean, they've been charging
Yeah, we're
the law.
Yeah, we would just be dropping it for patients. Like if we pick you up and you want a copy of your medical records, we just wouldn't be
Okay.
charging the patient directly.
Yeah,
If an attorney's office or some other kind of retrieval company requests those records the appropriate way, then we would still charge them what we're currently charging them.
Rachel, is this a policy that's been adopted by Commissioner's Court?
I have no idea. This is a policy that was located in my office, that we've been following. So I'm not sure if it's ever made it across Commissioner's Court.
So
All right, so the backup that we have that has the 4 bullet points on it, is that your existing policy with number 4 added? Is that what that is, Rachel?
Let me look, hold on, pull it up.
What's your thought on that, Ms. Allen? What are you thinking on that?
No, all I'm thinking is that if it's a court adopted policy, which isn't a fee, which I would assume it would be, then what the court really needs is the full policy with markouts of the change requested, so that it's documented through the court.
Yes, so the page that I submitted with the 4 points, that would kind of be the one that we would follow.
Okay, but I mean, what Patricia said, do we have a policy where we already charging them? Are we
I
charging
don't, I
those?
don't know if the county has an official policy. I know when I took over, this is the policy that was in our office that was being followed. Except we were charging patients, obviously. But I don't know if that is, if it's ever been brought to court or if it was just kind of a practice that was being followed within our department. So this is kind of one of the things that we've found that
Okay.
we're trying to clean up, alter, fix, do the right way.
All right, so maybe rather than do something we don't need to do or don't do it right, why don't we, let me just defer this, 2 more weeks down the road? And let you get with our,
There
Yeah.
is no authorization to charge a fee without the court.
Yeah.
setting-
So I guess, Rachel, what policy, where does this fall in your policy manual, I guess, of EMS? I
This
mean,
is
you have
just
a policy.
Of our office procedures for when somebody comes in and requests medical records, there's a form or medical record release form that they have to fill out. They have to show their ID. There's a whole form for it and they pay their $25, either cash, check, card, and we give them their medical records. That's just the policy that was in place when I came in the office. And so we're just trying to clean it up. So
It's an
the,
internal policy.
It's an internal policy, but it sounds like it needs to be a
Adopted.
external, yeah. So,
Yeah, I'd say bring that back with this and we can do it all at once, right?
yeah, I think I
make
agree
an
with
actual
that.
policy.
Yeah, they'll make an actual policy for you. So we'll just defer it for 2 weeks and you can bring it back.
okay, so what I submitted,
Bring it
So y'all-
back with the original policy, so we have it here with us.
If you can find one.
If you can find one, if not, bring it back and then we'll deal with it.
okay.
All right, we're gonna pass on.
We'll
20.
pass you.
All right, thank you, Rachel.
Number 21, discuss and take action to approve order 2024-64 to amend the budget for the fiscal year ending September 30th, 2024.
Thank you.
Two changes, that presented for. One is the transfer from operations to capital for the purchase of the sign machine approved at the last meeting. And the other is the recognition of the receipt for a service for 134,000, and then adding that to the operations budget of Road and Bridge Precinct.
I'll make
Sounds
a
good.
motion to accept order 2024 was it 64?
Yes.
Yes, sir.
I'll second that.
Moving seconded, all in favor, raise your right hand. Motion carries. 22, discuss and take action to approve counseling service for current jurors as authorized by Code of Criminal Procedures 56A.205.
Clinton?
The protocol procedure laid out an option. Commissioners can choose to do this, and it's our recommendation of the judges that you do this. It does not cost the county anything. What it basically says, what you do is you're authorizing jurors who have, whether they be grand jurors or actual jurors in a pettit trial, that if they've been exposed to difficult subject matter, I'll phrase it that way, then they can get up to 10 hours of counseling without a cost, and there's no cost to the county. And essentially, this would authorize this particular company you see in the backup, their firm or whatever, they're willing to use
You know,
and so,
We got it.
or we'll get that to you if you want to have it, but there was a particular company that the judges have really paid attention to.
so there's two companies. One is just jurors, and then the second one covers jurors and county employees also.
Do we have to pick a company or? is
We
that
knew
something-
both.
Just
So,
do both of them?
Yeah.
Yes.
And he said no fee. If the person stands up the counseling, they owe $65.
Yeah, if you don't keep your appointment, that's on them. But if
Yeah.
they-
Not
It's
us.
not us.
It's not us.
Okay.
So my motion is to approve both companies for the juror, whatever this stuff is. There you go. That's not a very good motion. You got that, Carrie? All right, moved and second, all in favor, raise your hand. Motion carries. 23, discuss and take action on authorization to apply for the 2024 unclaimed property capital credits from the state, from Texas Comptroller of Public Accounts. That's my motion too.
Second.
Moved and seconded, all in favor, raise your hand. Motion carries. 24, discuss and take action on replacing HCAV system at the senior center to be paid with facility project funds. Thank
Larry.
Cheryl gave y'all bids a while ago.
Have one more bid to add to that.
Yep.
Ain't nothing.
Yeah, it was right here, okay. I'm lost it.
It's a single page, not that one,
This one is for
not that one.
Rude brand. I had it earlier.
15-ton system,
I did have it.
There it goes.
which is the same as the previous low bid.
That's the cheapest.
Same equipment as the previous low bid. Just he wrote it in a hurry, so he didn't spell that out. I did talk to Mr. Riley and he confirmed it's a Rude system.
So you going back with basically the same that was in there, Larry? Pretty
Yes, sir. There's
close.
a-
Tonnage is
there's a
big enough.
There's a Rude condenser and a Green air handler that's over there right now. And they're basically, they're owned by the same parent company, so it's just a difference in the name. But what we're asking to go back with is a Rude complete Rude system.
It's big enough to handle the building.
Yes, sir, 15 tons.
So
Same deal, one part, 5-year compressor.
Yes, sir. Same, that's just the standard
Yeah.
factory warranty.
I guess we
You don't-
recommending.
2 year of labor warranty and
That's on a different vendor.
the one saying.
Riley's got it.
He's got.
Also has 2 years.
It says 2 years
Oh, 2
later.
year later.
It does say 2-year labor, 1-year parts, 5-year compressor, 2-year
1
labor.
year parts, 5-year compressor, 2-year labor
Yeah.
on that.
That's your
The
recommendation.
first year on that labor, the first year would be covered by the manufacturer, and the second year, that's the standard. The second year that he's offering would be under his expense. So how, on labor.
Did you get these, how can this guy separate from this guy? Did we give like a deadline and he came in at the very, very end and just didn't make this, or how did we do that?
Well, sir, so we had those 3 bids that were on the tab. Mr. Davis over with the senior center had Mr. Riley come by last Friday when he learned about the problem. This is the bid that Mr. Riley sent.
So how'd you get, I guess I'm gonna be sure that, is Cheryl okay with this?
Yes,
Yes, we
You're good.
yes, it's informal. It was informal. when we
Okay.
submitted the bids.
All right, I'm fine with that then.
Okay, so we're going with Riley's. Is what we're
Right.
saying. Okay.
27,000.
I'll make the motion to approve agenda item 24, the selecting Riley's air conditioning as the vendor at the price not to exceed $27,000.
Second.
Moved and seconded, all.
So the bid was presented timely to the purchasing department, or was this bid submitted after all the others? After the time they were supposed to be submitted?
There wasn't a deadline.
There was no deadline.
We just asked them to submit a bid.
It was not
There
formal.
was no deadline.
Just informal.
We called them and said, hey, we have a project. We need it done, and then they submitted their bid.
Okay.
Did I get a second? Is that you, Danny?
I made the motion, Bill second.
No.
He
yeah,
made the
I
motion.
second.
Yeah.
I can't even remember
Sorry.
what I did.
Moved and seconded, all in favor, raise your hand. Motion carries.
Thank you.
We're gonna pass on 25.
Pass it, 26.
Pass on 26. 27, discuss and take action on the extraterritorial jurisdiction agreement between the county and the city of Huntsville.
Judge, with the several things, I guess, over the last several years have changed. Way back in the example we have on the screen, several years ago, I guess 2001 or so, the legislator told the cities and the counties to get together and figure out who's going to manage the ETJ. City of Huntsville and Walker County, we have an agreement with them where basically they're in charge inside of the ETJ. And, we defer to them and their development code and stuff inside these regarding subdivisions. Over the last few years, the last two legislative sessions, for sure, the legislature has stripped away the city's ability to annex new areas. And the current, I guess, really starting 5 or 6 years ago, the city of Huntsville has been very reluctant to annex any areas anyway. So with that in mind, I thought it was a good time for us to kind of revisit with them a little bit and ask them their thoughts on moving forward with our ETJ, who, how in charge of it do they need to be or want to be? With the fact that they're never going to, was a pretty good chance they're not going to annex the properties in the future. Anyway, that was always the plan. They regulated the ETJ because they would come out and annex it and it would become a city street. Well, now what we're seeing between Sterling Ridge and my precinct, Texas Grand Ranch to the south, are these roads that will always be county roads. But the city oversees the installation of them and does all the inspections and signs off. And then, I know the last one in Sterling Ridge that I did, I had to go back and have them redo. And I think there were some troubles in Grand Ranch and
Well, yeah,
Timberwilde.
Timberwilde, we
Timberwilde.
got some inspections out
yeah,
there.
Timberwalk, kind of the same thing, but they turn them over to us. So it's been a while since we all sat around the table and visited. So I guess the whole thing today would be to recommend that you create a committee, Judge, on the county side that we can kind of visit here first, kind of figure what we want to do. And then we'll come back and visit and decide if we're going to visit with the city or not. So it's not really a motion, it's just a discussion to see where you want to go with that.
I know me and Andy's met with them a couple times, so we'll get a committee together and start negotiating, talking, or whatever you want to call it.
Okay.
Now, good?
That's good. I don't think I
Sounds
need a
good.
motion for that, just a discussion there.
You want a motion?
I think we
Okay,
need
all
one.
right, 27. 28. Discuss and take action on Dean and Ann Hall or Ann Day request for variance to section B 2.9 and section 4.18 of the Walker County subdivision regulations regarding required utility easement and right of way for plat number 2024-015. Replots of lot 16, 17, and 18, block 2, section 4 of Wildwood Shore subdivision.
Just the variance to leave right of ways and utilities in some place along the private roads. As the clouds are previously approved.
That's kind of what we normally do anyway, isn't it?
Object.
So.
I'll make a motion with accept number 28 as written.
I'll second it.
Moved and seconded, all in favor, raise your right hand. Motion carries. 29, public hearing concerning plat number 2024-015. Replats of 16, 17, and 18, block 2, section 4 of Wildwood Shore subdivision. Time is 9:33.
Public hearing for the combination of combining 3 lots into a single lot, known as lot 16A.
Anyone here to speak on that? Yes, sir.
Yes, Your Honor. We're intending on combining the 3 lots to build a home and for. I guess I don't know exactly
Yeah, you're good.
how to speak on it. We want to, the lots are rather small. We can't build across the lines unless they're joined, so that's why we're requesting this.
Yeah, can you state your name, please?
Dean J. Day.
Yeah, no clock.
Yeah, no, anytime we can combine lots out there, it's always positive. They're all small.
We appreciate that.
All right. Time is 9:34. We'll close public hearing. Number 30, discuss and take action on plat number 2024-015. Replat of lot 16, 17, and 18, block 2, section 4 of Wildwood Shore subdivision.
I'll make the motion, we approve agenda item 30 as presented.
Second, 2
Moved
seconds.
moved and seconded, all in favor, raise your right hand. Motion carries. 31, discuss and take action on waiver of permit fees for DPS waste station project.
Yeah, they're putting in a septic down there and I thought it's best if we just kind of waive what fees we can. There is a state fee we can't waive, right? And
$10.
surely they can handle their own side. If they can't handle the state side, it's gonna be bad. But anyway, I'm gonna make a motion to waive our fees.
I'll second that.
Moved and seconded, all in favor, raise your right hand. Motion carries. 32, discuss and take action on right-of-way acquisition report for Bruce and Jane Springer on Scales Ranch Road and Abram Peck Survey.
Yeah, we got some more right of way out there, and this is the one that's actually on Scales Ranch, and they got a little bit in the next agenda item too, but I make a motion to approve getting right away from, who was it?
Springer.
From the Springer on Scales Range.
I'll second that.
Moving second, all in favor, raise your right hand. Motion carries. 33, discuss and take action on acceptance of right-of-way easements from Bruce and Jane Springer on Scales Ranch Road.
Motion to approve.
I'll second that.
Moving second, all in favor, raise your right hand. Motion carries. 34, discuss and take action on right-of-way acquisition report for Bruce and Jane Springer on Fraser Lane.
Same people, just going up a different line on a different road, that joins them. Make a motion to approve 34, item 34.
I'll second that.
Moving second, all in favor, raise your right hand. Motion carries. 35, discuss and take action on acceptance of right-of-way easement for Bruce and Jane Springer on Fraser Lane.
Motion to approve.
I'll second that.
Moving second, all in favor, raise your right hand. Motion carries. 36, discuss and take action on Morgan Cole request for variance to section 8 of the Walker County subdivision regulations regarding private subdivisions for the proposed Oak Shadows mobile home park.
This has been up there before, and then.
But, yeah.
This is the updated response letter.
190?
Y'all have previous one.
190.
They updated it.
On that.
A little different.
You have a name? Everybody looks like county employees.
Cole, Morgan Cole.
Okay.
Yeah.
Which way, Bill?
It's mine.
You have any mail line on Timothy Manuel? Stephanie's here with Lyle. Do you have any questions?
We do. I've looked at it. It's, we've been pretty strict, especially in the mobile home subdivision. I'm making a motion we decline the variance request.
Moving second, decline. Moving second, all in favor, raise your right hand. Motion carried.
I do.
Danny. All right, we're gonna skip to 38. Discuss and take action on Piney Wood Ranch Partners Project regulatory jurisdiction determination in relation to Walker County regulation requirements. We just flip flop 37, 38.
Morning.
Morning. I'm Tyler Epstein here on behalf of Pineywood Ranch Partners. You have two items in here. This year. One talk about jurisdiction location of the project, and when we talk about the nature of the project. Yeah.
I look at this, whose precinct is in?
That's me.
Bills.
Very northwest.
Oh, this is up on 230?
Yeah, I don't know where it is.
Right up there comes to the.
This came.
So here's 230.
Yeah.
There. So the first item that we're here to talk about, is we have a division of land that's going on, along 230.
The line that he presented.
Well,
We think it's.
Or has gone on. You'll rotate this where that is to the north. Thank you. So, no, that's good. So the county, this line that's drawn
That's it right there.
here, this light line that you see here, you see a copy. This is, I think where the developer believes that the county line is at. We have some source of that, and he's gonna talk about that to you. the actual marker text dot is down about right here. I have an exhibit, I'll show you all that. Yeah. So the car represents the actual access, and then this line is pointing to the this line's pointing to the sign here.
Yeah, there's a sign right there.
Yeah.
Stephen.
Yeah.
Yeah.
Here
you go.
So there's a couple of questions that developers asked us to bring before you guys today. The first one is jurisdictional. Which lots are in our county, and then how our county rules apply to what was developed. So the road has been developed, or some kind of drive, a private drive, been developed. I'll let him go into a little more detail about what position on that is. It runs parallel to the line that's shown on here. Inside the marker that's shown out here, we would require normally development permits for that type of development within our jurisdictional boundary. The current Walker County subdivision regulations, consistent with what is required under state law, they do allow division of tracts 10 acres or larger, but require minimum frontage on the county road as part of that exemption or current regs that are adopted. These lots over here front on an existing county road.
Both around.
Right. These lots in here, in this area, whichever are in or out of our county, take access from along this constructed road here.
So that's a private road?
It's not county maintained, it's not been through our process, and there remains some question as to which side of the county line that road was constructed on. I think he's gonna get into that and kind of present what his feelings are, what his beliefs are on that today. The reason we put this together so that talk to you guys. What you guys are looking at here is what I'm using for basis. This is their text dot permit where they applied for the access. Indicating that it's on the Walker County side, which would make it jurisdictionally something I have to deal with. That's some part of the question. The second part is application of our rules, but I think I'm going to talk about do we have jurisdiction to enforce our rules? Would be another big question. And so he's here to kind of tell you what he knows about that and talk to you a little bit about that.
So this is just a screenshot from the CAD map, the Walker County CAD, and it shows the red line being Walker County's boundary. With that being said, so we took it there's political boundaries are always fun. And local government code chapter 72 defines how to establish political boundaries. If there's confusion between the county where their political boundary is, then the county is to hire a surveyor, contact the adjoining counties and figure it out. Now, with that being said, what we did is we took all of the best available evidence and established that line, including these lines that run through here. Multiple surveyors across the Walker County line have established this line. The CAD agrees with this line. And that's where we came up with this boundary and where the road was placed. As to Mr. Isabel's statement about the text dot road sign, that is one of those things that they put out there. That it was not surveyed. It's not a marker. It is a sign. And it probably should be moved because it can be misleading, but at the same time, text dot does not regulate political boundaries. They just slapped it up close enough. That's a text dot boundary, not an actual political boundary.
Now, when we met last week, you mentioned that y'all had done research and had at least 4 different data sets on this county differentiating line between us and Houston County. And I told you then that the first question I'm gonna ask you is, will you be able to bring those and show them to us? You told us yes, told me yes.
I don't recall that, and again, not arguing, I don't remember that. What I have is, again, this is where I brought the CAD map, because that's one of the evidences that we use. The image I just gave you, that's straight from Walker County Central Appraisal District. And it shows that red line is the Walker County boundary line, and it goes for as far as the eye can see, right, like on there. The surveyor, he took everything and placed the line appropriately according to everything else. At the same time, you know, if there's confusion about that boundary, then I think under the law, the county has to hire a surveyor for that under local government code, chapter 72.
Well, the thing is, here's where I'm at. We don't have confusion about it. We have a sign that was placed by the state that says this is a county line. And then you guys, whoever did this, believed it enough to go to Walker County and get the application for the road. So it seems like we're pretty strong in the fact that we believe that that is our line. We don't have to go prove a negative, that we're not going to go prove and say, no, it's not our line. We have two things that say, A, there's a sign. B, somebody else thought they were in Walker County. And once again, like I say, when y'all said you had, I was very specific, that you had 4 different, and you took the most conservative or farthest west.
So
And that's the line y'all established. So
that came from that conversation with the surveyor, and I'm not a surveyor. I just, you know, because this was one of those things that they did. I'm more than happy to get with him and prepare a report for that issue. At the same time, that is a TxDOT jurisdictional boundary, not a political county boundary. TxDOT has their own precincts, their own districts, and how they carve that up. But that was not, that sign is not surveyed out and put there with any kind of specificity. And TxDOT will not stand behind the location of that sign.
but
The CAD map to me is not helping you either, because I find discrepancies in this thing all the time.
that was,
Oh, don't get me wrong, and that's why you know, it's just an image.
Yeah.
And so, you know, the issue being is the county boundary is, you know, we said it's one place, y'all say it's somewhere else. That's, you know, that's a political boundary. At the same time, it's a red herring under the new law. It doesn't really matter where the boundary is under chapter 232.0015F of the local government code for subdivisions and platting.
Well,
So the reality,
go ahead. I'm gonna make the difference. What is your conversation with Houston County?
Houston County is, it's a private road. They're not gonna maintain it. They're good. They have no issues.
All right, the parts of it that's actually in Walker County that's off of that road, though, they have no access to a public road, county road, which is our policy, right, Andy? That's
So-
where I've got an issue at this point. I mean, because you're not even
Access.
conforming to our policy at all.
Well, it's the state, so the only way that the counties can regulate subdivisions is to chapter 232 of the local government code. And specifically, the authority is granted under 232.003. And so as long as we have an exception from 232 as a whole, then there's no ability to have to be platting or follow any subdivision regulations. And the state gives those freely. In fact, on page 35 of y'all's exceptions here. So there's exceptions by law, which is highlighted here in your government code or in your subdivision regulations. It specifically calls out a couple different things. One, it calls out the court case Elgin Bank versus Travis County, which is the case law that establishes their exceptions to subdivision regulations. The county can and cannot enforce them. And then 2, it specifically calls out in A2.2, in accordance with section 232.0015, Texas Local Government Code, as amended, the filing of a plat is not required when the owner does not lay out part of the tract described by Texas Local Government Code 232.001A3. And when the subdivision meets one of the requirements listed below, which we meet 8.2.1. Local Government Code 232.001A3 was updated in September of last year. To clarify a few things. So here is the law as it was on 232-1 last year, before September the 1st of 2023. And give me a second. And here's the law as of September 1st. And you'll notice at the top, I have that you can define by date when the law goes into effect to clarify the difference. So you'll see that in September or August of 2023, it required a subdivision if the road was going to be dedicated to the public or the users of the property that was being purchased. And then on September 1st, under House Bill 3697 or House Bill 3699, 232 was updated, and it removed the section where it was required for the people that were going to purchase property. So if it's not, and we are not dedicating this road to public use, where this is a private road to be used by the subdivision owners.
Let's,
So just so you know, our policy where he was reading on A2 exceptions for all, you continue reading past the requirements below, it says in compliance with 232 local government code. These regulations, in order to qualify for exception, all daughter tracks must meet the minimum frontage requirements as required by these regulations. That's the rest of the paragraph. Also in your section 11, you require all lots, including those subject to an exception, must have a minimum frontage length as described in appendix B 2.1 on an existing county road, unless otherwise typically allowed by these regulations. So we do quite often actually issue exceptions to subdivisions containing all tracts over 10 acres that have frontage on an existing county road.
Or a state road, a public road.
Yeah, under your rules, you allow the other. So, but we don't issue exceptions or agree to exceptions that don't include frontage on a public road. So the ones, this is kind of a little bit of a quandary for me because I have some tracts that are along an existing county road and may indeed have sufficient frontage along that road. Based on my eyeball and scale, my guess is most of those exceed 125 foot of frontage that are along Bo Brown.
talking about the Bo Brown tracks, right?
But most of the rest of the tracks, and regardless of where the line is, some of them, I think, the developer takes note are in Walker County, at least some, not all.
Is the entire road that we're talking about in Houston County?
That's one of the
And then
questions.
the land next to it and in Walker County, is that,
That's one of the questions. So
because I mean, that's,
they believe that it is in Houston County. I don't want to put words in your mouth, but that's my understanding.
But they sent it to Huntsville to get a permit.
But based on the application for the road entrance and the existing TxDOT marker that's marking, it says, Walker County and Houston County, it would, at least a portion of that road be within Walker County. So that's why one of the things to talk about here is jurisdiction. The other is about application.
Bo Brown. Oh, Bo Brown?
Not Bo Brown over here.
Yeah, Bo Brown's on the right.
Okay, it's on.
as long as I've been over.
Yeah,
Can we visibly point
Well, you, I don't know.
yeah,
I
exactly.
know where it's at.
that him in perfect?
Okay, this comes in the back. All right, I'm with you.
Just do the conversation.
So, to clarify too, I believe y'all's laws require the county road frontage. And y'all get that authority from 232-101. I do not have all of 232 with me today, but it's 232.103, I'm sorry, lot frontages. It requires frontages on existing county roads. If the road doesn't exist, then there isn't a requirement because it's only required for existing county roads. And on the existing county road, Bo Brown, we follow all the exceptions under 232.0015F. And to that extent where in asking for an exception to follow the law is kind of difficult, as in, the state issues my driver's license. I don't need to call Walker County and ask if I can drive the speed limit or if I can drive in your county. That comes from the state. So the exception is granted unless we violate it, then you can enforce it, a different way, but we don't have to ask for permission to follow the law. Is our standard.
So on the road. Will anybody driving up 230? Okay. Are y'all gonna call out these roads as easements right away separate from the property, or is the property owner gonna own the property all the way to the center of the street?
It's a private road they own to the center of the street. There's a private road agreement, where they have it in there. They own, everybody, each one of them owns the road.
And so you're gonna have and so if everybody owns out to the road, there'd be easement across the road. And easement is granted to who?
To each of the property owners inside the property.
So will you have a gate up at the front?
There is a gate up the front.
There is a gate at the front to lock people out or
Yes, sir.
to keep restricted to private.
It's restricted if you don't have the combination. And you don't get in.
I like to visit with.
Okay. We're gonna go into executive session under 551.071. 071 at 9:56. I mean, everybody needs to go to the hallway.
Yeah.
Back.
All right. Okay.
Right.
Time is 10:15. We're back from executive session on number 38.
I'd just like to, kind of defer this for 2 weeks. Just take this information we have under advisement, do a little consulting and, bring it back in 2 weeks.
Can I make one request before we roll on that? There's a gentleman on Bo Brown Road that owns property that cannot get an electrical permit right now. It met all the requirements. It's on a county road. If we could his permit so that he could move forward with his building. As in,
Let me look back yonder.
Wait 2 more weeks.
I just saying, I'm telling you, my opinion's no, but that's where I stand on.
You don't actually have an agenda item.
Yeah, we don't have anything to do with
Okay.
this. I got a motion. Are we just gonna pass them?
Yes,
You're talking about item 38.
38,
Yeah.
yes, we're passing 38, and then I'm gonna recommend we pass 37 also, because it depends on
38.
what we find on 38.
All right, we're gonna pass on 38 and 37.
2 weeks.
Yep, gonna do it.
Policy manual workshop. Amy? Tina?
I'm packing up.
Andy, get out of the ladies' way.
Now I got some.
You done, Andy. The only one that had more than you this time. The agenda would have been short if it hadn't been.
Yeah.
Yeah, we'll be gone. Thanks to Amy.
Tina?
Tina, maybe it's Tina.
So we try to look at the policy of a whole every 5 to 10 years. It's been 9 years, so TAC came in and looked at it. They made some changes or made some recommendations. So based on that, we picked some together for you all to look at. It is y'all's thoughts, your opinions. These are strictly tax recommendations. We don't have to do any of them except the ones that are by law. And those are kind of in here as well. But I'll turn it over to Tina and let her start.
Would you point out the bylaw so I can have that argument right up front?
Yeah, no need.
A lot of the lawyers are still sitting back here.
So do you want to go through all of them? Like one, like on this page that we sent y'all, like 1.03, then go to 2.01.
2.01, I guess, is gonna be my main concern as far by law. And then if it is by law, then I need you to show it to me. Not that I don't trust you, but
I'll speak to that. We don't have enough time, I mean, despite all the case law makes it clear that there are certain protected classes in our society that you cannot discriminate against. And as the decades roll by, more protected classes are added. And so it's basically US Supreme Court case law. You see it being written into administrative laws, fair housing authorities, where we were in law school, they call them the 7 special classes they're actually referred to in the policy here. That's in fair housing authority, statutory basis, there's stuff in the Civil Rights Act, all these very codified what it is. I did make a recommendation that it's unnecessary where the sexual orientation is mentioned. It's unnecessary to give varieties as examples. Just use the phrase sexual orientation. And I'll make this overarching statement. All the elected officials and all the department heads can hire and fire and promote and demote and not promote and not demote. Not hire for any legal reason or for no reason at all. That will state. You have those 2 blanket authorities. What you can't do is any of those things for an illegal reason. Because if you do one for an illegal reason, they're drawing a lawsuit from the county. And so the listed items there can all be found in various US Supreme Court decisions scattered out over the last 60, 70, 80 years now. So that's the legal.
Thank you, Quentin. Not that I agree with you, but
So we just want to put sexual orientation.
do what?
Take out the rest of them.
Yeah. Sounds good.
Well, I'm not gonna be leaving it in there regardless, but you're going against God and everything else. I have an issue with it.
You put it in there as we're not equal opportunity employer, all the other stuff,
It says based on sex, that should be good enough,
that'd
race,
be good
color.
enough regardless of what you call yourself.
Yeah, that's what Quentin said. Take the rest out.
Yeah, but
Yeah,
take sexual
they left the
orientation and
orientation
gender
in.
identity out and I'll be happy.
But if you don't include certain words when you apply for grants and other fundings, a lot of times that's in along with your fair housing statements and stuff like that, these exact
It
paragraphs.
always goes back to money, one way or the other.
Well, I'm just, I think,
Doesn't
I think
fix,
the sexual orientation one is pretty generic. You can leave it in there.
So is the sex one, Bill.
Mhm.
So is the sex. That says just about enough,
Well,
regardless of what you want to call yourself.
I don't care what anybody says, there's only two genders, animals even know that, people don't. I just don't care what the people say.
Yeah, okay, take note of that, Tina. Next one.
I'm sorry, that's where I'm
Yeah.
at on it. Animals are smarter than folks,
So you
evidently.
want us to go down, like tell you that
Y'all got any more to pull out or
I
talk
didn't really
about?
see anything.
That's the one I'm.
The same statement was also in the harassment.
Yeah, I made the same recommendation. No need to do it.
Okay.
Double category.
And then I had sent a note to Amy because we referenced a different various types of employees.
like that's
We
right.
referenced emergency medical director as a salaried employee, but we did not define salaried employee policy. That's the only place it's mentioned. It's his or her position, but we don't define it as to what it is. They varying it from exempt or non-exempt. We had that conversation. When we were talking about the fire marshals,
Yes, yes, sure.
clarify that definition. If we're gonna assign
you
it,
have a
I didn't get
definition.
past that other page.
I don't have, I asked for one. Yeah, we just need to find out
Okay.
what the legal definition of salary,
We're talking about.
the salaried versus exempt. We have two right now, the emergency medical director and the fire marshal. I think we ended up under the same definition for both.
Called salary.
And we specifically call out a salary, our policy says the emergency medical director is a salaried employee. We don't define salaried.
And policy, what was it for?
2.02 on in policy on employee status. Talks about full-time, part-time, variable, it's number 13. So for us, notice director is a salary employee who works on call basis.
Yeah.
Concern is that that's different from.
Well, we did it, rather than have a category that we put people under, we picked a paragraph and put a person in a paragraph all by himself. And since that time, we've added the fire marshal and said he just like he might be salaried also. So rather than having a definition and tiering employees under it, we wrote a paragraph around one employee. I'd much rather have a definition that we could tier people under versus a paragraph for an individual employee.
I'll probably go along with that one.
Sound pretty good?
Yeah, you done good on that one.
All right.
I'm impressed.
Instead of having his separate one,
It just make it number,
we could leave it the
Make it
13,
number-
but kind of change it to be salaried employees are.
yeah.
And then do the
Define.
two examples that we have, and if we add a third one.
And yeah, and you don't even have to put a person under it for that. You just put the category. Then the name comes out and it's just a category.
That makes sense.
That's the only one.
Instead
that-
of listed as an EMS director.
I did want to call your attention to 7.01, the process on late on Friday. You have traditionally had a step process waiting who are under department, with that fourth step being come to you as a the three-step process for employees of elected officials.
You got one question.
This proposal is to get rid of the fourth step, to stop at the third step. And as long as you're good with that, I'm good with that. In fact, I recommend it, but even as proposed and put before you, there are, step 3, parts C and D are now superfluous.
Sure, y'all are good with that, removing 4, and if we remove 4, then we would take out the C and D on 3.
So basically, the department head is the final, will be the final level now. I mean, it would come to me and my turn.
Right, and for me, looking at that from consistency, each of you as elected officials, you're the stopping point inside of your office, and your department heads, as a court, you appointed them, and you've given them the authority to hire and fire and promote and discipline and all of that. If we keep that fourth step, then you're not undermining them, but you're putting those employees in a different class than you are the ones that serve for elected officials. You still, because these are not elected officials, these are appointed officials, you still have the ultimate authority, because you can decide, we don't like the way you're running your office, and replace that person with someone you think could run the office better. So you still remain in the ultimate control. Yes.
But a person, I'm looking at Carrie just made, I have to, someone go with her. If Carrie runs a person off out of her office and she's the only appeal, that person has no grievance process.
That's correct.
I don't like that.
But that's the sanctity of the elected official. And so that's gonna be legal and statutory and constitutional. So that's why that's the way it is. You got 22 elected officials here in the county. They're the last word. Now you got 10, 8, maybe 2 others that might qualify that are department heads that you as a court have appointed to be in those positions, or a panel of judges have appointed to be in that position. And so their employees, their grievances logically and consistently should stop at the appointed head. And if you don't like the way the appointed head is working as the body, you can replace that person, not get involved in the grievance process. Now, for the record, we didn't make this recommendation. This came from TAC. When I saw it, I thought through it, and I see the logic of it. Ultimately, it's still your call, but if you're going to drop the fourth step as recommended by TAC, then I'm saying you need to drop step 3, C and D, because they're purpose.
So if I signed the change of status that terminated an employee out of my precinct, my guy, so my 10, 11 people, whatever number that is, my decision's already been made. They have no appeal. Their next step is just legal.
That's the way it has to be with elected people though, Bill. I mean, this court can't run another elected office. I mean, we set policies and things like that, but they're internal. Yeah, I mean, basically we fund it.
Yeah.
But when it comes to their employees, they're the final step.
Statutory language is zone of influence, and an elected official is pretty much sacrosanct inside the zone of their influence. And so that's what your policy has always been.
Right.
The elected, you stopped at step 3, stop with the elected. All this proposal from TAC is that even the department heads, it should stop with them. As opposed to having this fourth step of coming to commissioner's court.
So which employees in Walker County qualify for a grievance? Period.
Every employee in the county
They're gonna-
qualifies for a grievance.
They're gonna go file a grievance to the person who fired them and signed the change of status to terminate.
The grievance isn't necessarily only for terminations. If you don't like that you got passed over for a promotion or whatever, you can file a grievance. It's
If you-
going to
with-
stop.
Let me clarify that. If
With-
they've been terminated, they can't use the grievance
Correct.
process.
Okay, well,
Termination is the grievance
Yes.
process. Grievance is for the way you're being treated in the workplace.
but they're still gonna, I mean, maybe it'd be the way it is, but it seems weird that, I'm sorry, you don't get that position. Here's my piece of paper hiring Miss Johnson over here.
Yeah, but another elected folks, I mean, if we're sitting up here, okay, Sheriff, you know, we don't like what you did, so put him in that position. That shit ain't gonna work.
I don't like it, but it may be the way it is, just because of the way, I mean, we operate weird here.
Hey, this is one of them you need to accept.
All right, I'm just gonna, all right, let's go on. to that one.
Don't plant your flag in this.
Hey, nothing personal.
Go to the next one. Fine, let's go to the next.
Just accept it. It's right and let's move on. You don't like it, but.
So. I'm just gonna run through them real quick. One, we just basically defined or put the addresses on where to find the judges in the HR department. We're gonna work on 201. 202, I did have a question on this one. So tax says. Basically, any employee that works over 30 hours. They,
Wait a minute, tax second over 30 hours.
30 hours per week.
Did they say per week?
Yes. It's 30 hours per week.
That wasn't in the original.
Correct. So we left it out, sorry. We went back and reclarified with that. So it's 30 hours per week is what makes you eligible for benefits. Our temporary employees, whether they're full-time or part-time, there's policy in here that says they're not eligible for any benefits. However, tax said what they're seeing is a lot of counties are putting in a temporary position, a grant writer, a project that's not gonna be more than a year or 2 years. It has a specific end date. But those people are working full-time. So they're suggesting that if you want to have a temporary person, that is something that insurance does allow. It has to be the 30 hours a week, 30 or more per week. But it's regardless if they're temporary or full-time. So I didn't know if you were interested in that. The policy says it does take y'all's approval, but then it would take funding for that as well. Or we just leave it the way it is, temporary employees, regardless, get no benefits.
Part of my concern is, I know Will and I talked about this. So you hire a temporary employee, you know, they're gonna work for, say, 6 months. And 1 week they work 24 hours and the next week they work 35 hours. Next week they work 16 hours. I mean, how does the 30 work? You know, is it only the week that they work that much that they get?
So what we would have to do is, I mean, if they're a floating, 1 week, they're gonna be a few days, next week, they're something else. It's the 30 consistent over a period of time, and they can't really define what that period of time is. So if you're truly gonna be almost a part-time temporary, then I think you don't do that. But if you're gonna be a full 40-hour every week employee until this project is done, that's where they are suggesting that. And we can completely scratch it and leave it the way it is. And I'm good with that too. That was just one of the recommendations.
But I don't like the word may in anything. Because once again, if I give it to Mrs. Smith, I choose not to give it to Mr. Johnson. Now I've got troubles. I don't know why I need, that's a huge liability to dangle out there for somebody.
Don't change it.
Yeah, I think
We
we,
don't have to.
I think we just leave that out. That's my
Yeah.
thoughts.
Yeah, I mean, if you're working 40 hours a week, you're full time.
Yeah, just take that out.
To go forward is where we're gonna, do our pre-employment stuff, the drug screening stuff.
Yeah.
Did have a question, and that may be more of a budgeting thing that we can look at later on the 2.22. When you're paving the $12 per day. I don't know if that's a good amount.
That needs to go to $15.
I'll go along. with
I
it.
don't disagree on the 15. I mean, we typically try to live in that, but
I mean,
it's
that's-
hard.
It's hard to feed a person for that
Do
amount.
we get county per diem on anybody else? Like a meal per diem?
Well, those, the
This is
per
not
diem
really-
would be for the travel, it's 20 or 35, but this is for when they're,
I get that.
I'm sorry.
I just didn't know if it would keep it all the same.
Really, I think.
We're gonna feed them cheap.
Well, no, I understand that.
And always get stuck paying. extra.
Chicken, Aston does good. Boy, she keeps them in there.
Yeah, but
I mean, that was just the question, and I
Can't go
mean, I
for
know it's
hamburger.
hard to. eat.
Oh, no, 12's hard to live with.
So I didn't know if that's something y'all.
I think 15 would be a good number. Yeah.
$2.15.
I've got a big budget anyways.
Yeah, we got a really big budget.
Yeah.
Well, when you go over the 12, you pay for it. Tricia, make sure.
Yep.
And I don't mind, but
We don't go.
I go over every time.
Hey, we don't feed them as well. That's why we like coming and working.
That's why
with
they
you.
like to come work with me.
So do y'all want us to go ahead and do it now or wait till budget time, get with Trisha on those?
I just think do it now.
Well, it's gonna take a vote to do it. I mean, we can't vote it. Yeah, I'd say do it.
And I think, I mean, the rest of them are more just changing some wording, the major things and like statutorily, things that have to be done every time that there's a change, we do those individually. But every policy hadn't been looked at in, like I said, 9 years, so we just had them review that. And these were some of the changes that they came up with.
So the 2.15 also has the little statement in there that me and Ronnie does not
Yes,
like.
so we will edit that.
What about, so clarify this for me, on 4.03, when it's talking about the, on bullet point, 7, the max comp time. Says the max comp time acquired, accrued by, for any employee is 240. Well, that's not true because EMS, Road and Bridge,
Just don't get comp time.
yes, exactly.
Then on
We're tapped out at 40.
On page 2, well, so go down,
And I know it contradicts it in here somewhere.
Did it say any?
so on 7A, it spells out that Road and Bridge is gonna get 40. B, the dispatch is 40
Yes,
and
dispatch, that was the other.
EMS is 40.
Yeah.
But back at the very beginning, it says
Says any employee
eligible employees. Certain
Yeah.
employees aren't eligible for comp.
on number 7, it says for any employee. Would we, I mean, because that's,
We'll work on that word.
it's basically grammar, I guess.
And I mean,
Yeah.
put eligible in there, yeah.
Yeah.
Like,
That was the only other thing I saw that,
unless y'all want to start giving me comp time, I don't have.
I don't want to hear it.
County go broke.
Yeah,
We can't give Quentin. comp time.
that's why we kept it ours at 40.
Vacation hours and mile.
Come on, we'll give him a vacation.
I forced him to go.
Let him go next court, because I got some stuff I need to bring next court. Yeah, next
Oh,
court.
anyway, let's get back on subject.
Those changes put together, those policies, bring them all back officially for y'all in 2 weeks. So look at and if there's anything in between that y'all see, then we can.
I'm officially gonna have a problem if it's got those two things in there. I'm just gonna point it out to you.
Thank you, though, Amy. I know you've listened to a couple of them. Rant and rave a little bit.
Yeah, I know my lawyer's still looking at me, but I'm just telling you.
I'll have Tina bring it back so y'all can know with her.
I can say this, whatever the feds post on our wall, their verbiage is what it is, but this is our policy. And the one word sex to me covers it all. That's the way I see it.
Any other comments on workshop? All right, no need for executive, public comments, Ms. Johnson. You're up. If you'll come up here and state your name, Ms. French, you have 5 minutes. We can't respond to you.
You have waited a long time patiently.
But Ms. Johnson, if you want to visit after court, I'll visit with you.
There you go.
I'm sorry.
If you want to visit after court, I will visit with you again.
Okay. Hey. Good morning. Thank you all for seeing me. My agenda has to do with my drainage easement that is on my property.
Yes, ma'am. Come on.
You can show us. We just can't really respond to you.
I'll give you this.
I wanna, oh, that's wrong. Oh. I guess you can pass on one.
I'll look with him. He knows where he's at anyways.
Yeah, I know.
I want y'all to have a, y'all know where it is?
Yes, ma'am.
Okay. And I don't know. If I have- basically what it is, I spoke with you a couple of years ago.
Yes, ma'am.
You came out to the property. I had just gotten in my auto accident.
Mhm.
That auto accident. And, basically, there is, I also have pictures, so I guess you wanna.
Yeah, but they may want to look at it.
Yeah, it's pretty bad because the property out there, I know it's not. The demographics is not. I guess the best demographics, which a lot of people tend to frown upon, I guess, that area. But we are a, good group of people. And, our neighbors, we bond together, we help each other out on everything. So, basically, whenever my yard needs to be cut, my neighbor, he comes over, he cuts my yard. He's a high school student. However, when it comes to the weather, like what just happened, all the rain, my yard is the worst of it. And as you see in the picture, I had said that I was gonna use my slide to show you the pictures, but I don't know if I have time to kind of show you. But it looks as though I have like a lake. So, it got really bad this past week. We were pretty much scared because I thought it was gonna get in my house. So as you can see, that shows across the street. And this is what, my neighbor has to endure. She's pretty much dug up a lot of that so that it won't just sit there, because when the water backs up into my yard, this is what it does over in her property. It backs up into this large, kind of like a hole. Yeah, and it, if you continue, it shows. This is after it rains. It just sits in my yard like that until it can actually flow through the other end on her yard. And these puddles, this is when it just first starts to rain. That stump and all of that, basically it all gets covered. And all of that, the mud here, that's where we park, believe it or not. And if you continue with the slides, that post there is where the culvert is. And it's basically covered. And you can't even see it because it needs to be, we try to keep it mowed out and it's all covered. And it's supposed to go across the road, but it's two small little barrels that go across the road, but they're not big enough. They're not large enough. So I asked that they be enlarged because there is a pond at our neighbor's yard behind me. When it rains, his pond overflows and it flows all the way down. And then my neighbor to the left of me or to the right of me, his yard and everybody else's yard runs down into that drainage that's supposed to be large enough, but it's not. And it gathers all into my yard. And then it starts to flow back up into my yard. 1 minute.
Oh, okay. And if you continue the pictures, it shows all of it.
Yeah.
And that's all I have. Oh, that's all of it? Well, the other pictures that I sent y'all, you can see, my kids had to literally park, on a high plane that's over to the right side of my property. And basically, my granddaughter, I have pictures here. We have snakes that are coming from the property, from the water sitting. We have mosquitoes that continue to be on the property because of all the water. And so I have pictures of her, the bites.
Oh my.
We can't even go outside for them to play. We have pictures of the snakes that are on my porch. So it's really bad.
Thank you.
Thank you, Ms. Johnson.
Thank
If
you,
you want to visit Epicor, we can visit some more.
Yeah.
No, you can take them. We got any questions from media? Commissioners, Commissioners Court.
Yes, huh?
is there anything? Yeah, adjourn at 10:46.